Hi, everyone. Sean Gilliam here. Welcome to this episode in which I'm going to cover the exclusive right to sell listing contract. This is a document that's put out by the Colorado Real Estate Commission. It's their approved document. This is the document that we'll use if I'm working with you as a seller that will make me exclusively the broker that works with you in the process of selling your home. So there's some important pieces of information within this contract. I'm going to highlight some of the major ones as I see it, especially those items that are negotiable, and review those with you. A lot of it too, though, is boilerplate language that our attorneys at the state level put in here. That's also very important for you, but I'm not going to spend a whole lot of time talking about those things. But let's go ahead and get started. I'll read it here at the top in the bold text. This is a binding contract. This form has important legal consequences, and the parties should consult legal and tax or other counsel before signing. This is an important statement for you to understand. We have to tell you that you have the right to get legal and tax counsel or other counsel as you see fit. And so if that's the case, what I advise to clients is that if you do want to talk to an attorney or consult with your tax accountant, make sure that you get enough time to do so, because sometimes that can take some time to get an appointment set up, to get your questions answered and those kinds of things. You're not required to use any of these outside sources, but again, you are advised according to this contract to consult with other parties to make sure you have all your I's dotted and T's crossed before you move forward. The next important statement here is compensation charged by brokerage firms is not set by law and is fully negotiable. So that's a conversation we'll have when we get to Section 7 that talks about how much I'm going to get paid. And if you want to pay a buyer's agent, you can talk about that at that point to see if you're willing to pay a buyer's agent any compensation for the purchase of your home. Then this next statement, different brokerage relationships are available, which include buyer agency, seller agency, or transaction brokerage. I do have another video that talks about the brokerage disclosure to buyer that actually covers these definitions. So you can also consult with that to get some more information. But when we get to Section 5 and 6 of this contract, I'll lay out those definitions more thoroughly as well. So now we get into the beginning of this contract. The agreement, it talks about the seller and brokerage firm enter into this exclusive irrevocable contract and agree to its provisions. Broker on behalf of brokerage firm agrees to provide brokerage services to seller, and seller agrees to pay brokerage firm as set forth in this seller listing contract. Now, when we get to Section 2, quick and simple, I belong to a brokerage that has multiple people working for it, meaning multiple brokers. So it's a multiple person firm. Not much to go into there. It just means there's several agents that work in my office. And then we get down to the defined terms. Your name will be there. And typically what we want to do when we put your identifying information in any contracts or paperwork, we want that to reflect what you have on title. So everything's consistent. And then the brokerage firm, Location Real Estate, is the firm I work for. That's my name. And then, in property, obviously, we'll put your address and other important information, the legal description, what have you. So we make sure we're talking about the right property. If your home is in an affordable housing community, or it's deeded as affordable housing, as it states here, if this box is checked, seller represents to the best of seller's actual knowledge that the property is part of an affordable housing program. If this box is not checked, seller represents that the property is not part of an affordable housing program. So make sure you know you'd probably be familiar with that because you likely bought the home as part of an affordable housing program, and you would be aware of that information. So that'd be a discussion we'd have to have. All right, and then we move on to sale or lease, 3.6. A sale of the property is a voluntary transfer or exchange of any interest in the property or the voluntary creation of the obligation to convey any interest in the property, including a contract or lease. It also includes an agreement to transfer any ownership interest in an entity which owns the property. Now, I typically don't do leases, so if this box is checked, seller authorizes broker to negotiate a lease of the property. That's not my area of expertise, but if you are trying to have a broker negotiate a lease for you, that's the box you would check. 3.7 is a fairly important section of the contract, the listing period. So this is how long this contract will be in effect for. And I'll read the paragraph to you. It says the listing period of this seller listing contract begins on, and we'll put the date, perhaps the date that we're having this discussion and we sign the document, and continues through the earlier of the completion of the sale, or if applicable, the lease of the property, and any written extensions for the listing period. Broker must continue to assist in the completion of any sale or lease of the property for which compensation is due and payable to brokerage firm under Section 7 of the seller listing contract. So this is negotiable. The listing period cannot exceed 1 year from the date of the start of this contract or the beginning date. Typically, I put about 6 months. In our current market, homes, by the time they're listed and by the time they go under contract, it can be, 50, 60 or more days, depending on the area and the community. So that's an important thing to consider. Otherwise, we have to go back and do an amend to the listing contract. So a lot of times I'll give 6 months or maybe a little more. But again, we cannot exceed 1 year. So that's important for you to know. So you're not locked in for the rest of your life with a particular listing agent. All right, I'm going to scroll past 3.8 and 3.9. Pretty straightforward. It just defines some terms. If you have any questions about this, don't hesitate to get in touch. But we'll go down to Section 4, the brokerage relationship. And it states in 4.1, if the seller agency box at the top of page 1 is checked, broker represents seller as seller's limited agent or the seller's agent. If the transaction brokerage box at the top of page 1 is checked, broker acts as a transaction broker. So I'll scroll to the top to show you what those boxes are. Right under exclusive right to sell listing contract, am I serving you in a seller agency role or that'd be transaction brokerage? And we'll scroll back down here to Section 4. There's a few other terms or scenarios that are important that are laid out here in this contract. It's a well-written contract. 4.2 states in-company transaction different brokers. So when seller and buyer in a transaction are working with different brokers within the brokerage firm, those brokers continue to conduct themselves consistent with the brokerage relationships they have established. Seller acknowledges that brokerage firm is allowed to offer and pay compensation to brokers within the brokerage firm working with the buyer. So this means you're protected. I have to conduct myself consistent with the uniform duties and agency duties. If you have me working as your agent instead of a transaction broker, I have to serve you well and protect your interests, as we'll see in Section 5 and 6. So just because somebody's in my office doesn't mean I can talk loosely and share things that might interfere with your ability to negotiate in a transaction. I have to be just as careful as I would in other situations, but even more so because people are listening and might eavesdrop and hear things that might benefit them and work against you. So as a professional, my job is to protect you in all those circumstances. 4.3, in-company transaction, one broker. So if seller and buyer are both working with the same broker, the broker must function as, and there's several different scenarios here that they define. So if I'm working with you as your agent, the parties agree that the following applies, and I'll read 4.3.1.1. Seller agency unless brokerage relationship with both. Broker represents seller as seller's agent and must treat the buyer as a customer. A customer is a party to a transaction with whom broker has no brokerage relationship. Broker must disclose to such customer the broker's relationship with the seller. However, if broker delivers to seller a written change of status that broker has a brokerage relationship with the buyer, then broker is working with both seller and buyer as a transaction broker. So what this means is if you make me your agent, if we check the seller agency box at the top, but we've already had a discussion that, hey, if I bring a buyer and I've got a transaction brokerage relationship with them, then you're okay with reducing the level of service to you from that of an agent, which is a fiduciary, an advocate, somebody who's in your corner, to that of a transaction broker, which is more of a facilitator and a messenger. If you're okay with that, if you're comfortable with that, then we can do that. The benefit to you is that you will potentially save money on commissions. We can negotiate that if I'm handling both sides of the transaction, we can lower the commission amount. The con to this, or the thing that works against you, if you really want somebody to be in your corner and advocate for you, then reducing my level of service to that of a transaction broker would not be in your best interest. And so we would not do 4.3.1.1. Which leads to the next section, 4.3.1.2, seller agency only. If this box is checked, broker represents seller as seller's agent and must treat the buyer as a customer. So if you just want me to serve as your agent only, and if I bring a buyer, then I can only treat them as a customer, then you're going to want to check this box. And then we get to 4.3.2, which defines transaction broker. If the transaction brokerage box at the top of page 1 is checked, or in the event neither box is checked, broker must work with seller as a transaction broker. Transaction broker level of service is the default. So when we first meet, that's the level of service I provide for you by default. A transaction broker must perform the duties described in Section 5 and facilitate sales transactions without being an advocate or agent for either party. If seller and buyer are working with the same broker, broker must continue to function as a transaction broker. And so now you see how those roles are defined and the different scenarios in which they would apply. And that's a discussion we'll have. If you want me to be your agent only, then we'll check that box in 4.3.1.2, or we'll start out with me being a seller agent and then have the option to switch to transaction broker if I bring a buyer to the table and me handling both sides of the transaction is okay with you and you're okay with the transaction broker level of service. Now we get into Section 5, and this defines the brokerage duties, as I've been referencing several times throughout this contract. Broker, on behalf of brokerage firm as either a transaction broker or a seller's agent, must perform the following uniform duties when working with the seller. So if I'm working as a transaction broker or an agent, these uniform duties are the responsibilities that I have to provide these things to you in our brokerage relationship. So I'll start with 5.1. Broker must exercise reasonable skill and care for seller, including but not limited to the following. I must perform the terms of any written or oral agreement with the seller. I must present all offers to and from seller in a timely manner, regardless of whether the property is subject to a contract for sale. The Real Estate Commission or the Division of Real Estate likes 24 hours or less. I'm pretty quick on things. As soon as I get information, I'm texting you, calling you, shooting you an email with an offer in hand, that kind of thing. So that way you have that information right away. 5.1.3, disclosing to seller adverse material facts actually known by broker. So if there's anything I know about a buyer, I'll do research when we get offers and find out, if they're getting a loan, are they pre-qualified? Who's the lender they're using? I'll talk to the lender to see what they say, how strong of a buyer they are. Or if it's a cash offer, I'll seek out information on proof of funds. So that way you'll know if there's any risk involved, if there's any concerns with the buyer's ability to finance, or if they have a home to sell before they can purchase yours. All those kinds of details I'll share with you so that you know. 5.1.4, I have to advise you regarding the transaction and advise you to obtain expert advice as to material matters about which broker knows, but the specifics of which are beyond the expertise of broker. So that would be an area, or I have to tell you if there's something that I'm not an expert in and advise you to get some additional information. Some of that might be, hey, we know there's some issues with the property or the foundation, that kind of thing. I would refer you to a structural engineer to look into how significant of an issue this is before we put the house on the market, or so that we can advise buyers of a potential concern with the property. That's just one example. So if it's something that's beyond my pay grade or my expertise, I'm advised to tell you that and then advise you on some references on people you can call to get a professional opinion on things. 5.1.5 is straightforward. Account in a timely manner for all money and property received. 5.1.6 is keeping you fully informed regarding the transaction. And this is something I do with my sellers. We'll have multiple points of contact throughout the week, whether it's text message, phone call, because there's always important information to share with you, or even just to give you an update on what's been going on in the market overall, as well as in your local neighborhood, so that you can kind of get a sense of what's happening And that will help, if we need to consider doing a price reduction or what have you. But I will keep you fully informed regarding the transaction. 5.2. Now, this section is important because these are things that I must not disclose to anybody without your informed consent. 5.2.1 states that I am not allowed to share that you're willing to accept less than the asking price for the property. This is especially true when we start out of the gates. We don't want to let people know that you're willing to negotiate lower. We'll just say, hey, bring us your best offer and we'll take a look at it. 5.2.2, what the motivating factors are for seller to sell the property. I get this a lot, especially at open houses. People ask, why is the seller moving? I'll give some generic, they just want to. But I won't give specific details because that could potentially impact your ability to negotiate. They might see you as desperate, and so they'll come in with a lowball offer or what have you. We just want to let them know that it's time for you to move on or something similar, whatever you advise me to say. And then they can write their offer without any motivating factors impacting their decision on what they're going to write. 5.2.3, I'm not allowed to disclose that you will agree to financing terms other than those offered. So in the MLS, based on what we see later on in this contract, you can choose to accept a conventional loan, an FHA loan, a VA loan, a cash offer, whatever the case may be. And those are the terms that we'll stick to. Now, if a buyer does come with something different, I'll still present that offer to you, and you can decide if you want to accept that offer or not. But I'm not going to tell people or prospective buyers that you're willing to accept an offer with financing terms other than what you've agreed to. And then 5.2.4, any material information about seller, unless disclosure is required by law, or failure to disclose such information would constitute fraud or dishonest dealing. So this is where the seller property disclosure comes into play. I do a video on this. Basically, my advice to people is err on the side of over disclosing. It honestly does not hurt you. If you are honest and share every little detail about the home, any adverse material facts, that actually presents well to buyers because it lets them think or helps them to feel like you're being honest and that what they see is what they get. They're not going to worry about any information they'll find out later that could potentially cause them to want to terminate, because that wastes people's time and it doesn't help your situation. So it's best to put everything out there up front and let them make an informed decision. 5.2.5, any facts or suspicions regarding circumstances that could psychologically impact or stigmatize the property. Once in a while, we'll have a home where a crime was committed and the listing agent, and if I'm working for you as your listing agent, I am not required by law to disclose that to anybody. That is on buyers to do their own due diligence to figure out if a crime was committed in a home. So that is where you're protected. And this is to keep your property from having a psychological stigmatization that, hey, this is where this happened. You don't want to buy that house. That could potentially hurt your ability to sell your home. So by law, we are not required to tell that information to the public. Then we get down to 5.3, and this states that seller consents to broker's disclosure of seller's confidential information to the supervising broker or designee for the purpose of proper supervision, provided such supervising broker or designee does not further disclose such information without consent of seller or use such information to the detriment of the seller. So there will be situations where we come across an interesting situation or a difficult situation, and we have to make a decision. And I'll advise you, I'll say, hey, look, I'm going to talk to my managing broker to see what best practice is in this situation. And I'll let you know that, but this contract also allows for me to do that for your benefit. 5.4 states that the brokerage firm that I work for may have agreements with other sellers to market and sell their properties. Broker may show alternative properties not owned by seller to other prospective buyers and list competing properties for sale. So that means by law, I'm allowed to have a couple of listings in the same neighborhood. And I might even show prospective buyers not only your house, but other houses that are listed by my brokerage firm, or for that matter, any brokerage firm. So this just lets you know that it's just part of a fair market that I'm allowed to list other homes that might compete with yours or show buyers other homes that might be competing with yours. 5.5, broker is not obligated to seek additional offers to purchase the property while the property is subject to a contract for sale. So if we're already under contract, I'm not obligated to, but you and I will have a discussion to see if it's wise to consider backup offers or to go back to other buyers that have looked at the property and say, hey, this deal might not make it. We'll see what happens, but just wanted to let you know, just in case your buyer's still interested in writing an offer. So there are those situations that will come up. 5.6, broker has no duty to conduct an independent inspection of the property for the benefit of a buyer and has no duty to independently verify the accuracy or completeness of statements made by seller or independent inspectors. Broker has no duty to conduct an independent investigation of a buyer's financial condition or to verify the accuracy or completeness of any statement made by a buyer. So this frees me from liability that I don't have the requirement to prove anything that anybody has said. I don't have the requirement to verify anything. And indeed, I don't have the expert or professional skills to independently verify the accuracy of information put out by inspectors, contractors, buyer's financial condition, or what have you. I'm just going on word of mouth, and I'm trusting that people are telling me the truth. And that is the information that I will convey to you. I also don't have a responsibility to do an independent inspection. So if you fill out that seller property disclosure, I'm taking you at your word. I don't have the requirement to go out and prove what you said is true or to do an independent inspection to verify what you said is true. So this frees me of that liability. Quite honestly, it'd be a lot of work. And again, because I don't have expertise in some areas, it'd be impossible for me to do it. And then 5.7 states, seller understands that seller is not liable for broker's acts or omissions that have not been approved, directed, or ratified by the seller. Again, this goes back to communication. You and I will be having conversations. I'll present some ideas to you. You'll have some ideas to share with me, and we'll figure out the best course of action. And then I'll go out and carry out exactly what you told me. I won't do anything less than or in addition to, primarily because that could potentially impact your ability to negotiate in a transaction, among other things. So I'll stick to whatever we agree on and move forward with that. 5.8 is important because when your house is listed, I'm going to get calls from buyers agents or even buyers themselves asking what kind of traffic we're getting, if we have any offers on the table or any offers coming in. And this section addresses that. Generally speaking, I think it's good to check the will box. I'll go ahead and read this paragraph to you to fully define it. It says, when asked, broker will or will not disclose to prospective buyers and cooperating brokers the existence of offers on the property and whether the offers were obtained by broker, a broker within the brokerage firm, or by another broker. If broker wishes to disclose the terms of any offer, broker must first obtain the seller's written consent. So again, I think it's important to have the opportunity to share with prospective buyers or their agents that you do have an offer or there's an offer potentially coming in, because a lot of times that puts a fire under that prospective buyer to get an offer in by the offer deadline, just in case we've set one, or if there's an offer in with an acceptance deadline of noon tomorrow, to inform them that, hey, we'll look at your offer too, just get it into us by noon tomorrow so we have time to take a look at it and make a decision. So generally speaking, I think it's good to allow me to disclose, but we can cover that and you can tell me if you're interested in me doing that or not. Section 6 talks about the additional duties of a seller's agent. So all of Section 5 are the default responsibilities I have to you in that transaction brokerage role. Section 6 then stipulates the additional duties that I owe to you if I'm your agent. So I'm going from being a broker to an agent, a transaction broker, I should say, to an agent. And so again, it says if the seller agency box at the top of page 1 is checked, broker is seller's agent with the following additional duties. 6.1, promoting the interests of seller with the utmost good faith, loyalty, and fidelity. And so I'm in your corner. I'm trying to get you the best deal possible. I'm trying to negotiate on your behalf and have you put out as little money as possible. So I'm promoting the interests of you, and some of those interests you'll define as we go through a transaction or elsewhere in this contract. 6.2, seeking a price and terms that are set forth in the seller listing contract. So later on, we'll set a listed price for your home. And so my goal is to get you that much money, if not more, but not less unless you agree to it in writing. 6.3, counseling seller as to any material benefits or risks of a transaction that are actually known by broker. So this is where I'm your advocate. I'm giving you advice. I'm getting information so that I can counsel you as to any material benefits or risks. In contrast, if I'm just a transaction broker, I'm giving you the offer and you take a look at it and let me know what you think. In that role, I'm just a facilitator or a messenger. But as an agent, I'm going to review that with you and say, hey, these are the ifs and the buts, and these are all the kind of pros and cons of each of these offers or this offer in particular. This is my advice to you. And so that way you have all the information at your fingertips to make the most informed decision moving forward. And so these are the additional duties, in addition, I should say, to Section 5, those uniform duties that I would provide to you if I'm working specifically as your agent. And again, I want to point out that real estate agent is a generic term that's used all the time. But as far as a contract is concerned, that term agent is a very specific legal term that means that I'm your fiduciary, that I'm carrying out these roles in Section 6. Otherwise, like I said, I'm a transaction broker on your behalf. Section 7 talks about compensation to the brokerage firm, specifically how I get paid, but also if you're willing to pay the buyer's broker, it's also stipulated in this section as well. Now, I do want to stress that you do not have to pay the buyer's broker anything. I will have you pay me a fee for my services, but you do not have to pay the buyer's broker anything. Or you can pay them a negotiated amount. As I said at the outset of this contract, that compensation is not set by law and everything's negotiable. I'll go ahead and read this here. It says, seller agrees that any brokerage firm compensation that is conditioned upon the sale of the property will be earned by brokerage firm as set forth herein, without any discount or allowance for any efforts made by seller or by any other person in connection with the sale of the property. 7.1 talks about the amount of compensation. In consideration of the services to be performed by broker, seller agrees to pay brokerage firm as follows. 7.1.1 talks about the total amount of sales compensation to be paid. So that can be a percentage amount of the gross purchase price or a flat dollar amount in US dollars. Now, it's important to point out here that whatever is in this space here will include my compensation and the buyer's broker's compensation if you choose to pay compensation to the buyer's broker. When we get to 7.1.1, it states if buyer's brokerage firm procures a buyer and the transaction results in a closing of the sale of the property to such buyer, seller's brokerage firm may enter into a compensation agreement with the buyer's brokerage firm to contribute from the sale compensation amount of percentage of the purchase price, the gross purchase price, or a dollar amount in US dollars to the buyer's brokerage firm. So 7.1.1.1 stipulates how much you're willing to pay the buyer's brokerage firm for bringing a buyer and getting to closing. And then 7.1.1.2 is a protection for you. It states that if the seller agrees to pay the buyer's brokerage firm pursuant to the contract between buyer and seller, seller's compensation to seller's brokerage firm will be reduced by that amount not to exceed the buyer's brokerage firm compensation set forth in 7.1.1.1. So whatever amount you put in 7.1.1.1 will be subtracted from the amount here in 7.1.1. So that way you know that what is stated here under sale compensation in section 7.1.1 is your max out of pocket for compensation. There won't be any surprises or additions to that unless it's agreed to in writing, but that will be your max out of pocket. And then what is stated as what you're willing to pay the buyer's brokerage firm will be subtracted from that amount.
All right, we can scroll down to 7.2, when compensation is earned. Such compensation is earned upon the occurrence of any of the following: any sale of the property within the listing period by seller, by broker, or by any other person, as well as the broker finding a buyer who is ready, willing, and able to complete the sale or lease as specified in the seller listing contract, or any sale of the property within so many calendar days after the listing period expires. So that'd be a holdover period. And this would apply if I negotiated a deal with somebody and whose name was submitted in writing to seller by broker during the listing period. That person would potentially be eligible or qualify me to be eligible for compensation if you end up closing the deal with them. So that's the discussion we can have. This is negotiable. As it goes on to say, however, seller will or will not owe the compensation to brokerage firm under this 7.2.3 if a compensation is earned by another licensed brokerage firm acting pursuant to an exclusive agreement entered into during the holdover period and a sale or lease to a submitted prospect is consummated. So again, not to make this confusing, but if we have a listing agreement, it goes for 9 months, and then it terminates and you choose to go with another brokerage firm. If we have a holdover period here of, let's say, 30 or 60 days, I've heard of some agents do it even longer. But if during that period you close the sale of your home with somebody that I brought to you, as it mentions here, to anyone with whom the broker negotiated and whose name was submitted in writing to you as the seller, then I could potentially be due compensation. This is a conversation we can have, if you're going to work with me and we're going through this contract, but that's basically what that paragraph is talking about. And then we can scroll on down. Other brokers' assistance, multiple listing services, and marketing. And so this is where we talk about how we're going to list your property, what vendors it's going to be posted to, or websites it's going to be posted to. So I'll go ahead and read this paragraph. Seller has been advised by a broker of the advantages and disadvantages of various marketing methods, including advertising and the use of multiple listing services, and various methods of making the property accessible by other brokerage firms. For example, using lockboxes, by appointment only showings, etc. And whether some methods may limit the ability of another broker to show the property. After having been so advised, seller has chosen the following. And so we'll talk about that. Is it a good idea to have your property in the MLS or not? Should we put a sign in the yard? Should we allow showings with a lockbox or by appointment only where I meet them at the property? We can discuss those options, what you think is most favorable to your situation and the market conditions that we have. And so based on that discussion, you'll make a decision here as to whether or not the property will be submitted to one or more MLS multiple listing services. For instance, my listings go on Iris as well as RE Colorado. So it basically covers from South Denver all the way up to the Wyoming border and out from there. So it covers a lot of ground. And then whether or not your property will be submitted to one or more property information exchanges. So a lot of times when I put a listing on the MLS, it gets syndicated out to Realtor.com, Zillow, and many other websites, not to mention different real estate agents' websites. So they can look at it and they can post it. So it'll get out there if we put it on the MLS, which generally speaking is a good thing. So if submitted, seller authorizes broker to provide a copy of this seller listing contract to the MLS or information exchange. If requested, timely provide notice of any listing status change to such MLS and information exchanges, and upon transfer of deed from seller to buyer, provide all required sales information to such MLS and information exchanges. So this is kind of the nitty-gritty of what goes on behind the scenes. But basically, the choices that you want to make here are whether or not you want it to be on the MLS and whether or not you want it to be sent to Realtor.com or Zillow and some of these other websites. Now we'll look at 9.1.2. Seller authorizes the use of electronic and all other marketing methods except, and you can fill in the blank there. I've never had a seller come up with anything for this part, so I typically put none. But if there's some type of marketing method you don't want use, we can specify that here in the contract, and that will be how we move forward. And then we jump down here to 9.1.4. The property address will or will not be displayed on the internet. And then similarly, 9.1.5, the property listing will or will not be displayed on the internet. Generally speaking, we want as much publicity as possible, but there are circumstances where a seller will not want their home or their information to be on the internet. And so if that's the case, we'll discuss that and make plans accordingly. 9.2 talks about access to the property for showing specifically, but also for licensed appraisers, broker assistants if you want it, unlicensed inspectors, what have you. We'll get to that in a second. But the broker may access the property by, and I use manual lock boxes, so that's what we would use, and that's the box we would check there. And then other than broker, 9.2.2, seller further authorizes the following persons to access the property using the method described in 9.2.1. That's that manual lockbox. And we would put actively licensed real estate brokers. They have a responsibility to protect your property and to, as they show it to prospective buyers. Licensed appraisers, because at some point, if we're under contract and they're using a lender and they need an appraisal, we want to, at this point, already give permission for appraisers to get into the house. Unlicensed broker assistants. Sometimes brokerages will have assistants who are not licensed real estate brokers go ahead and show properties. Now, there's restrictions to what they can do. They can't answer questions. They can only unlock the door and let people in. So generally, I don't check that box. And for the most part, buyers come with their agent to the property, not an unlicensed broker assistant. And then the next option is unlicensed inspectors. That word unlicensed catches people. It sounds a little concerning, but inspectors are not licensed by the state of Colorado. So that's why they say unlicensed there. But basically, it's a home inspector. And typically, we want to give them access to the home so that the buyer can do their due diligence, their inspection of the home, and see if there's anything that they're concerned about, what have you. So typically, I check that box. But again, that's a discussion we can have. That's all negotiable. Sometimes we can check a box for other people to have access to the home, but generally speaking, real estate brokers, appraisers, and inspectors are the people that will gain access to the home. Taking a look at broker marketing in section 9.3, 9.3.1 states the following specific marketing tasks will be performed by broker. I have a blurb that I put in here that just talks about all those things that are the typical marketing tasks that I do for any listing that I have, whether that's getting professional photographs, whether that is putting it on multiple MLSs and all that kind of information. So, but there is a blurb that I put there. 9.3.2 is an important one for you to consider. It states seller authorizes videos and pictures of both the interior and exterior of the property, except so if there's something you don't want to have marketed or visual out there on the internet, this is the time to let me know that, and we can make sure we don't take pictures of that. When the professional photographer comes, I'll be there and I can point out, hey, don't take a picture of this, whatever the case may be. All right. For 9.4, I'll let you read that. It's pretty straightforward. In some effect, it talks about how that the information submitted to either the MLS or information exchanges may be difficult, if not impossible, to remove from syndicators in the internet and releases broker from any liability for broker's inability to remove the information. So once it's out there, it's hard to bring it back. So again, that's why it's important if there's anything that you don't want to be visible, whether by photo or video, that would be something we need to make sure we exclude from the marketing. Now we get down to section 10. These are your obligations to me. 10.1 talks about negotiations and communication. Since I'm representing you, all communication goes to and from me. So it goes on to say more specifically, it says seller agrees to conduct all negotiations for the sale or lease of the property only through broker and to refer to broker all communications received in any form from real estate brokers, prospective buyers, tenants, or any other source during the listing period of the seller listing contract. So if you're out in the front yard and somebody drives by and sees the sign and they ask about the sale of the home and they say they're interested, get their contact information and send it to me, and then I'll reach out to them and see if we can put a deal together. And then it goes on to 10.2, advertising. Seller agrees that any advertising in the property by seller, whether it be internet, print, and signage, must first be approved by broker. So we want to make sure that we're in compliance with MLS rules and other things before we put anything out there for the public to see. 10.3 talks about how you don't have an existing relationship with another real estate broker. So it says no existing listing agreement. Seller represents that seller is or is not currently a party to any listing agreement with any other broker to sell the property. Seller further represents that seller has or has not received a list of submitted prospects pursuant to a previous listing agreement to sell the property with any other broker. So this is important because if you are currently in a relationship, a professional relationship with another broker, I need to know that up front because I don't want to step on people's toes or violate any rules. And so if that's the case, then either you need to terminate your agreement with them and then work with me, or keep working with them. The second blank to fill in there is seller further represents that the seller has or has not received a list of submitted prospects. This is where that holdover period comes into effect. So if you have a previous listing agreement and there's a holdover period, we need to make sure that you're aware that you may owe them compensation, the other or previous listing broker, based on the contract that you had with them. So those are discussions we need to have, and to make sure that we have everything in order and not violating any rules or stepping on any toes. All right, so we can scroll now to 10.5, the Colorado Foreclosure Protection Act. This is an important discussion to have with me. What this would look like is if you are behind on your mortgage payments. So if you've missed a month or two or three even, that's very important for us to know up front because there's timelines and all sorts of important factors to consider in listing your home. So we need to know that up front so that we can plan accordingly. And then we get down to section 11. This is the price and terms. So after I show you the market analysis, what's happening in the market, what's happening in your local market especially, we'll come up with a price range, and then we can determine what price you want to list your home at. And so we would put that in 11.1. And then 11.2 are the terms that you're willing to agree to for purchase of your home. So that could be cash, conventional loan, an FHA loan, a VA loan, or some other option. But these are the things that I would explain to you, the pros and cons of each of these, and you can determine whether or not you're willing to accept an offer that is conventional FHA, VA, or cash. Now, we may get an offer, even though, let's say we don't check the box for FHA, because let's say your house needs a lot of work and needs a paint job. And typically, an FHA appraiser is going to look at that and not give the loan to the buyer until the house is painted. We can make sure we don't check that box. But if we get an offer from an FHA buyer, there might be some negotiation that goes on that the house could get painted, and the lender might be okay with it if we get it done after closing. Just throwing that out there as an option. So we may get an offer that does not coincide with the boxes that you've checked, and we still have the option to consider whether or not you want to accept that offer. And then we can scroll down to earnest money. Typically, about 1% of the purchase price of the home or the listing price. And then usually personal check or wire transfer to the title company that will be representing this transaction and performing all their operations regarded to the transaction. And then we get down to seller proceeds. How do you want your money, your net proceeds, to be delivered to you at closing? Do you want a cashier's check that you would take to your bank and deposit? Or do you want the funds electronically transferred? You have options. And so that's a discussion that we can have to see what's the best fit for you. And then 11.7 and 11.8 are all important things, but I'm not going to go into details on those. You can read those, and if it applies to you, we can discuss that. And then we get down to inclusions. So all the inclusions that you want to keep with the property. This is an important discussion to have, and we need to make sure that we get this set in stone right up front, because what you don't want to do is get under contract and then have somebody think that the washer and dryer are included, but somehow you changed your mind and decide you want to keep it. Now, sometimes a buyer might be willing to negotiate that if you do change your mind, but just to save us the burden of having to have that discussion, which may not go the way you want it to, it's best to get everything that you want included with the property up front and keep it that way. As we discuss inclusions with this contract, it's also important to let me know if there are any encumbered inclusions, meaning solar panels, things like that, where you are paying a monthly payment to pay it off, or if there's a lease, whatever the case may be. That's important for us to know so that we can represent your property accurately to prospective buyers so that they know that they might be taking over a lease for solar panels, or you might have to pay the solar panels off at closing, and we need to make sure that you have enough money in your net proceeds to actually pay that off. And then if there's any personal property that you wish to sell along with the house, now this is a tricky thing just because some lenders don't like that, so we have to be careful about that. But sometimes like a pool table, or if there's a lawn tractor or something like that that you want to keep with the property and have the buyer pay for some nominal fee, what have you. That's important for us to consider as well. That's a separate agreement, a separate form that we need to fill out. And so those are things that we need to discuss as well. And then when we get down to exclusions, are there things on your property that are family heirlooms or keepsakes that you want to make sure that are removed from the premises and go with you to your new home? We want to know what those are so that we can advertise that accordingly, so that buyers are fully aware that when they come to look at your house, that they know they're not going to get that uh, fixture that's on the wall. You're going to remove that and repair the wall as if it was never there. So they need to know that. A lot of times people will put in their custom drapes that they made that they want to take to their new home, for instance. And then we get down to any parking or storage facilities. If you have a shed in the yard that you plan to keep there, or if you want to take it away, we need to know that too. If there's any water rights, this is an important factor. If you own shares of water rights, that's something that we need to make sure that if you want to keep that or sell that, or whatever the case may be, that we handle that accordingly. And this is where I would advise that we get an attorney that specializes in water rights involved so that we do everything properly according to whatever your wishes are. One more aspect of water, specifically the source of water, we'll want to take a look at who the water district or municipality that provides water to the property, and we'll convey that information to prospective buyers so that they know. If you live in a community, a suburb, what have you, it's pretty straightforward. It's like city of Longmont or whatever the case may be. But if you have a well, we need to know that also so that we can get the permit from the Division of Water Resources. And I'll usually put a copy of that on the MLS with your permission, just because that's one of those things that buyers want to see. And if they can get access to it easily through the MLS, it just makes their decision a lot quicker and potentially get an offer on the table. So we'll look up what the well permit number is, as well as get a copy of that permit. And then we come down to title and encumbrances. 14.1 states, seller represents that the title to the property is solely in seller's name. So there's no other parties that I don't know about that hold title to the property. If so, we need to know that right up front so that we can make sure that they're all included in this process of selling the home. And then delivery of documents. Seller must deliver to broker true copies of all relevant title materials, leases, improvement location certificates, and surveys in seller's possession. Now, that's a very key statement there, in seller's possession. So if you don't have it, well, then you can't deliver it. And then you must disclose all easements, liens, and other encumbrances, if any, on the property of which seller has knowledge. So if you just got some work done on the house and you owe a contractor, umpteen $1,000, that's something that we need to know up front to make sure that you can get that paid before closing. So those are some things that you need to share right then and there. And then, like I said, if you do have a copy of like an improvement location certificate or a survey, that is a great resource to have that we can pass on to a buyer so that they can use it for their purposes. And a lot of times they'll want to see that as part of their due diligence research. So if you can get that to me as soon as possible, that way we can put that even on the MLS so that people can look at that.
Section 14.3 talks about conveyance of title. And as you see here in the sentence, in case of sale, seller agrees to convey the property by a good and sufficient deed. There are several different types of deeds. I won't go into all of them. Some of those I would advise you to talk to a real estate attorney to see, for instance, if a bargain and sale deed would be a good idea for you or a quick claim deed. But generally speaking, when we receive an offer on that contract to buy and sell real estate, either the special warranty deed box will be checked or the general warranty deed box will be checked. And when you convey title to a buyer, effectively you are saying that you guarantee that this title related to the property, this legal document, is free and clear of all defects of title, any blemishes on title, all liens and encumbrances have been taken care of, and they're just getting a clean title for the property. Now, this is communicated in different ways. So with the special warranty deed, you are saying that during the time that you have owned the property, you guarantee that the title is clean. There's no defects or blemishes. Prior to you owning the property, you do not guarantee that everything is okay with the title. By comparison, a general warranty deed, you are stating that during the time that this property has existed, not only the time that you have owned it, but also prior to you owning it, that there are no defects of title. Now, that sounds scary, but please know that title companies do a thorough job of researching title related to the property, making sure that everything is taken care of, that there are no unpaid liens, anything like that. So, and with that title insurance policy, that will also assist in taking care of some of these things so that when the buyer takes ownership of the property, they can be confident that there's, in all likelihood, nothing wrong with the title to the property. But if there is, the insurance will help to cover that as well. So bargain and sale deed and a quick claim deed, like I said, you can talk to an attorney about those. Personal representatives deed, this would be if you are representing the estate of someone who has passed away and the court has appointed you as the personal representative for the estate, then you would be the one that is handling the sale of this property, and we would check that box. Then we go down to 14.4 for monetary encumbrances. Property must be conveyed free and clear of all taxes except the general taxes for the year of closing, because those will be prorated by the title company. All monetary encumbrances, such as mortgages, deeds of trust, liens, financing statements, must be paid by seller and released except as seller and buyer may otherwise agree. Existing monetary encumbrances are as follows. And this is where you would share with me any outstanding debt related to a mortgage or sometimes more than one mortgage, as you can see by example there. If there's any unpaid liens, if you have a tax lien on the property, all that kind of information is important for us to discuss and list here so that I can give you a more accurate estimate of what your net proceeds will be for the sale of your home at closing. Section 15 talks about there being a title insurance policy related to the property and to the transaction, and who will pay for that. That will all be determined in the contract and how that is written out. And then 16, we get to association assessments. And this is important for us to know so we can communicate this properly to the buyers out there when they look at the property to see how much the HOA is per month. And I'll go ahead and read it. It says, seller represents that the amount of the regular owners association assessment is currently payable at approximately, and then we'll fill in the blank for how much per month or quarter or year, and that there are no unpaid regular or special assessments against the property except the current regular assessments and except, so if there is a special assessment that you know about that you have to pay to the HOA, we would list that here and make sure that you have the resources to pay for that at or before closing. For example, I've had a seller that had to pay a lump sum regarding a fence replacement for the community. And that was a special assessment that was agreed to by the HOA board. So it was official prior to closing. And that is the responsibility of the seller. So we just had to make sure that out of the net proceeds of the home, they had that amount ready to be paid to the HOA to cover the cost of the fence replacement. Then it goes on to say the seller agrees to promptly request the owners association to deliver to buyer before date of closing a current statement of assessments against the property. And so that will be sent to the buyer through the title company typically, or if you get access to that, we'll send that and make sure that they get that in a timely manner. Now I want to review section 18, material defects, disclosures, and inspection. And I have obligations as well as you. I'll start with the broker's obligations. It states Colorado law requires a broker to disclose any prospective buyer or to any prospective buyer all adverse material facts actually known by such broker, including but not limited to adverse material facts pertaining to the title to the property and the physical condition of the property, any material defects in the property, and any environmental hazards affecting the property, which are required by law to be disclosed. These types of disclosures may include such matters as structural defects, soil conditions, violations of health, zoning, or building laws, and nonconforming uses and zoning variances. Seller agrees that any buyer may have the property and inclusions inspected and authorizes broker to disclose any facts actually known by broker about the property. So you see here, it's very important that we disclose any adverse material facts about the property. And what this paragraph is stating is that even if you don't want me to say things about the property, by law, I am obligated to do so. And in doing so, I'm not violating my relationship with you, my professional relationship with you. It also goes on to say at that last sentence that you agree that a buyer can have access to the property and inspect the property itself and any inclusions. And that you are also authorizing me to disclose any facts actually known by broker about the property. So it's very important for you to know that. As I always tell my clients, err on the side of over disclosing. And this isn't just my opinion. This is advice from legal counsel. This is advice from experienced brokers that I've worked with over the years, managing brokers, what have you, that say it's always best to over disclose and be upfront about things, because this actually, contrary to what you may think, actually puts buyers at ease. It makes them feel like, okay, they're not hiding anything from me. They're telling me everything about this property. And most buyers, you'll find, will see issues with the property, especially if you're being honest and over disclosing. They'll most of those things, they'll be like, yeah, we can deal with that. That's not a big deal. Or maybe the seller can repair that at closing. It truly does not hinder someone writing an offer. And the people that it does, you probably don't want to be under contract with them anyway. But again, it's always advisable from a legal standpoint and for just creating a good transaction overall to err on the side of over disclosing. And the way you can do that is a commission approved form called the seller's property disclosure form. And I typically put seller agrees, so I check that box. I've never had a buyer say they don't want to do it. The seller agrees to provide on or before the sale contract's respective deadline a seller's property disclosure form completed to seller's current actual knowledge. Colorado law requires seller to disclose certain facts regardless of whether seller is providing a seller's property disclosure form or not. Typically, the contract requires disclosure of adverse material facts actually known by seller. So a lot of times what will happen is when you receive an offer on that contract to buy and sell real estate, they'll check the box for a seller's property disclosure form. And so they require that. Now, if you choose not to fill out the form and you just want to send an email with all the information, you're free to do so. What the law requires is that you disclose the information. It doesn't mandate that you use the seller's property disclosure form or any other form. It's just as long as you disclose it in writing to a buyer. Then 18.2.2 talks about lead-based paint. If the building permit was issued prior to January 1st, 1978 for your house, you need to complete a lead-based paint disclosure form, and that must be signed by you and me, as well as the buyer and their broker that's working with them, and allow them to evaluate if they want to do a lead-based paint assessment. But yeah, this only applies if your home was issued a building permit prior to January 1st of 1978. Carbon monoxide alarms. It's required by law that you have those within 15 feet of a bedroom. So make sure that we have those installed before we put the home on the market. As you can see in that last sentence there, you have to have them in place, applicable to the local building code prior to offering the property for sale or lease. And then condition of property, the property will be conveyed in the condition existing as of the date of the contract for sale or lease of the property, ordinary wear and tear accepted, unless seller at seller's sole option agrees in writing to any repairs or other work to be performed by seller. So basically, when the house goes under contract, you are not obligated to make any repairs. They are buying the house in the condition that it's in. And unless they ask you to make some repairs based on an inspection of the property and you agree to do so, you have no obligation to change the condition of the property. Section 19 talks about if we're in default, that each party has the right to cancel. So if I'm in default, you have the right to cancel, and if you're in default, I have the right to cancel. So if any obligation is not performed timely as provided in this contract or waived, the non-defaulting party has the following remedies. So in effect, as I mentioned, I can cancel the contract, or you can cancel the contract if either of us is in default. But I'll let you read the finer details of that. The brokerage firm also has the right to cancel, and you can see that short list. If any of the following are unsatisfactory, the property condition of the property or inclusions, any proposed or existing transportation project, road, street, or highway, any other activity, odor, or noise, and its effect or expected effect on the property or its occupants, or any facts or suspicions regarding circumstances that could psychologically impact or stigmatize the property. In the event brokerage firm exercises its right to cancel under this provision, brokerage firm waives all rights to pursue damages. So I've never had this happen before, but it is there, so read that and be aware of it. And then forfeiture of payments. In the event of a forfeiture of payments made by a buyer, the sums received will be, so if we go under contract and a buyer terminates or defaults on the contract and they're not allowed to do so according to the dates and deadlines of the contract, they might be subject to forfeiting the earnest money that they paid. If that's the case, that's what Section 20 is talking about, is where does that earnest money go? You got several options here. It can be paid to the seller in its entirety. It can be divided between the brokerage firm and the seller, one half to brokerage firm, but not to exceed the brokerage firm compensation agreed upon herein, and the balance remaining to the seller, or other. We can put in another option. If no box is checked in this section, choice one, paid to the seller in its entirety, applies. So by default, you get it all, unless we agree to splitting it somehow. Section 21, cost of services and reimbursement. This is protecting you from any surprise costs. We're not allowed to do that, as it states here, unless otherwise agreed upon in writing. Brokerage firm must bear all expenses incurred by brokerage firm, if any, to market the property and to compensate buyers' brokerage firms, if any. Neither broker nor brokerage firm will obtain or order any other products or services unless seller agrees in writing to pay for them promptly when due. For example, surveys, radon tests, soil tests, title reports, engineering studies, property inspections. Unless otherwise agreed, neither broker nor brokerage firm is obligated to advance funds for the seller. Seller must reimburse brokerage firm for payments made by brokerage firm for such products or services authorized by the seller. So all the marketing, all the services I will provide to you I'll be compensated for them at closing, whether it's paid by the seller, the listing brokerage firm, or by you, depending on how we agree on how my services will be compensated. But there won't be any surprises. It'll be in writing what I will be paid, and that, refer back to Section 7 of this contract to see what that amount is. And then disclosure of settlement costs. Seller acknowledges that cost, quality, and extent of service vary between different settlement service providers. For example, attorneys, lenders, inspectors, and title companies. So basically, it's stating that we don't guarantee that you're going to get the best quality of service or the cheapest or least expensive quality of service from the different vendors that are involved in the transaction. And then maintenance of the property. Neither broker nor brokerage firm is responsible for maintenance of the property, nor are they liable for damage of any kind occurring to the property unless such damage is caused by their negligence or intentional misconduct. So we don't have a responsibility, or I don't have the responsibility to maintain your property. That is something that you're responsible for, and it's in your best interest to keep your home in show-ready shape. Now, that is a conversation that I like to have with sellers. Like, I know you're excited about selling your home, or maybe they're not. It depends on the circumstances. But one of the more difficult aspects of selling your home is having it ready for people to come in and look at the property. And so it will be a disruption to your life, truthfully. And you just have to be mentally prepared for that and take the necessary steps so that the home is in its best shape for people to look at when they schedule a showing to look at your property. Section 24, I won't go into the details on that. It's pretty straightforward. We cannot discriminate against people based on those different protected classes there. And then recommendation of legal and tax counsel. We always advise people to get legal and tax counsel because this is a legally binding contract. There are important legal consequences. And so it's always in your best interest to talk to the appropriate professionals to make sure you know what you're signing, as well as everything that's involved in the sale of your home. Mediation, this is talking about if a dispute arises, it's built into this contract that there is a means or a way of getting things resolved. And then attorney fees, it talks about in the event of any arbitration or litigation relating to the seller listing contract, the arbitrator or court must award to the prevailing party all reasonable costs and expenses, including attorney and legal fees. So if it does get to a legal hearing, the prevailing party, the party that won the case, for lack of a better term, will have their attorney fees paid by the party that loses the case. And then Section 28 is additional provisions. If you want to put wording in there related to my services to you or how you want this, the parameters of this contract to have, we can put that there. And then if there's any attachments, no other party or intended beneficiaries in Section 30. Nothing in the seller listing contract is deemed to inure to the benefit of any person other than the seller, broker, and brokerage firm. And then 31 talks about how all documentation will legitimately be delivered between the parties involved. And 32 talks about modification of the seller listing contract. Unless it's agreed to in writing, it doesn't stand. So it's important that, any discussions or changes to this contract, there is an amendment for that, and we can fill that out to the satisfaction of both parties and get that signed, and then it becomes valid. And then the rest is boilerplate language. I'll let you take a look at that. So that is the exclusive right to sell listing contract. If you have any questions about this information, don't hesitate to get in touch. There is my contact information right there. Otherwise, I have other videos, as I've mentioned, that are out there that talk about other aspects of the buying and selling process, the seller's property disclosure video, and some other documents related to a transaction to buy and sell real estate. So take a look at those. And again, like I said, if you have any questions, feel free to get in touch. We'll look forward to talking with you soon. Take care.